On the basis of presumption of innocence, Your Worship, I pray that the accused person be granted bail there is a certain uncertainty as regards when the trial will commence. And in the likely event where the proceedings will end in favor of the accused person, Your Worship, in case he remains behind jail walls all that time, he will have suffered irreparable loss, Your Worship. The offenses with which the accused is charged are bailable, Your Worship. The accused Your Worship, the accused person has a fixed place of abode. That is Lusaka village, Machinde division, Kampala. He is a journalist. He is 34 years old. His phone number is 0701 87 09 59. Your Worship, we pray that you invoke your discretionary powers considering the presumption of innocence. The gravity of the offenses with which is charged. And the fact that the accused person has never been charged with any offense, Your Worship. Your Worship, on the court record there is an introduction letter from the local council where the accused person resides. Your Worship, there are 3 sureties to be presented by my land friend in Sibuka Haruna.
I need to give this one to court, Your Honor. I represent a surety, worship, a city of Your Worship, the surety is 856, resident of Saka village.
What is his name?
Asigenganda Ali. Asigenganda Ali. Worship is 856.
56.
Resident of Saka village. The accused person is an electorate and a long-time friend. Worship. It is the mayor. Division by council. Where the court has jurisdiction. His telephone number. Your Worship, covers Moses Wilberforce. Your Worship covers 856. Covers Moses Wilberforce. Page 46. Kabazi.
Who is he? He's the one?
56. He's a resident of the neighbor. In Akabidde. He is a brother accused person. He's a businessman owning a bank. His telephone number.
What's the name of this bank?
His telephone number is 0772 47 48 Your Honor, the last surety is Happy Charles. Wash Happy is 8 Happy Charles. 46 Your Honor. 36. No, 36. Happy. 36. Your Worship is a resident of Lusaka. The resident. His telephone number is 52 25 00 0772, Your Worship, 25 00 22.
How is this cut with
no time frame. And he's a businessman dealing with proceedings, always a proceeding. Your worship, we find that the sureties are sufficient and substantial, and we find them sufficient. And we invite this honorable court to invoke its discretion. We find the sureties substantial. Your worship, you have explained all their obligation to them, and they appear to have understood. Your worship, we pray for favorable conditions, most preferably in cash payment. Your worship, we so pray.
Is there an objection?
Object to the application. The following reason. Having in mind that the offense with which the accused person is charged with is bailable, as stated by the counsel for the accused person. And it is also noted that bail is not automatic, much as it is bailable. It is at the discretion of the court either to grant bail or deny bail. That is entirely at the discretion of the honorable court. But the discretion is supposed to be exercised decency. The court has to take into consideration when granting bail the public interest. Now the public interest also demands that the person be released on bail. Once we talk about the offense with which the accused or applicant is charged with, and it is bailable, yes, it is bailable, but it is also serious in nature. And that one has been read and it is known. It is a serious offense which affects actually. It can even affect the entire country. It affects the public. Much as it is presumed innocent. They are not condemning that it is already guilty, but that's the fact. The counsel also cited the uncertainty as to when this matter will be tried as one of the grounds that the applicant should be granted bail. Just, I wish to remind either the counsel that when the accused person appears in court, we already informed the court that the inquiry is complete. This matter was not fixed for hearing, basically because we were out of time, and today it was fixed for bail application. Counsel for the accused person tried to apply for bail, but due to time, it was fast. Okay. That does not mean that the inquiries are incomplete. Prosecution is actually ready to proceed with this matter and have it handled expeditiously, so that one should not be a factor for the applicant to be granted bail. The counsel also stated before the Senate report that the applicant has a fixed place of abode. I wish to inform court that this applicant, when he appeared before the police officer, the first thing is to establish his place of residence. And he stated that it's a resident of Chanja, that is in Akabidde prison, captured in the charge sheet. And that one was his first full particulars and also gave his phone contact with regard to that. But today, council has come up with another contradicting information with regard to the resident of the applicant, saying that the applicant is a resident of Lusaka village. Urban Council is marking division, different division now from Nakawa to marking, that's I don't know when he shifted, but now it's in marking division. So also these are not raised issue of doubt as to whether the applicant has fixed place of abode. Is doubt created by the applicant himself or the lawyer. But the fact remains that applicant's fixed place of abode is in doubt. I pray that also take into consideration that when granting bail, then the first surety for the applicant is said to be the mayor of this division. A mayor is somebody who owns duty to his subjects, being it the complainant, being it the accused person. The mayor owns duty for them as their mayor. So there is a conflict of interest. Mayor, as a surety, may fail to discharge his obligations because his interest will conflict. He has the complainant who are also his subject. The accused person also is a subject to mayor. Mayor is the head. In local, we even say the mayor is the president of that division. Local people conceive it in that way. So the interest of the mayor will conflict. You can't say, let me support the accused side. About the other one, they are also yours. How will you handle it being the mayor of the division? That's the issue to be taken into consideration. In that circumstance, I pray that the mayor should be found not substantial to some security for an accused person. This will be he also on duty for the others who are the side of the complainant. It will conflict. Then the two sureties must defended by the accused person.
Who is that?
These are the sureties that the person produced them by their friends. They are friends. So in an event, yes. But the third surety is a friend. That's a friend. That's what I mentioned. So in an event, the accused person happens to jump court bail. He may fail to discharge his duty as a surety, which the council for the accused person informed this honorable court that they were being taught of their duties as a surety. But to me, he may fail to discharge. His duty being a friend may not be able to praise the accused person in the event that he doesn't rush to the village. How will he praise the accused person? He may fail, just a friend in the city. He will fail. So on that ground also, and for the interest of justice, my humble prayer that this bill is denied, the matter is fixed for hearing, and is handled expeditiously, and his fate is determined. If he is found innocent, find guilty. The fate is determined. I so pray also.
Briefly rejoin your worship. We have not contradicted the prosecution as regards whether the inquiries are complete. What we have stated, your worship, is that we are uncertain as regards when the trial will commence. We are also uncertain as regards when this matter will be concluded. Why should he be kept in jail when there is a possibility of him being found to be innocent? And indeed he pleaded not guilty. Your Worship, my land sister for the prosecution has submitted to the effect that there is a contradiction as regards the residence of the applicant before you. But there is a requirement under the bail guidelines that every applicant should have an introduction letter as regards to his residence. The framers of those directions were aware that the prosecution normally indicates on the charge sheet the residence of the accused person. Why would it be required again for one to have an introduction letter? The accused person is at liberty to contradict the findings of the prosecution. Your Worship, on the court record, there is a letter by the local council authority confirming the residence of the accused person. And that residence is within your jurisdiction, Your Worship. Being Rusaka village in Machinde division, Kampala. Had we cited the information in the charge sheet, my sister would have objected, saying that they have not produced an introduction letter from local council authority. The information on the charge sheet, Your Worship, is a subject of scrutiny by this court. And that will come at trial, Your Worship. And that is information from the prosecution, not the accused person. Your Worship, the prosecution has as well confirmed that our client is a resident of Machinde. When she raised an objection against the mayor, Ali, being the surety, one of the sureties, saying that he will contradict his interests in regard to the complainant and the accused person, since both are his residents in Machinde division. that he owes a duty to both. Your worship, isn't that a clear indication that the accused person is a resident of much India? As regards the mayor having a challenge of contradicting interest, Your Worship, Myland sister for the prosecution has not cited any connection between the mayor and the case before you. Is not one of the witnesses or potential witness and Your Worship, the accused person is still innocent. There is presumption of innocence which he enjoys. Should the mayor be judgmental at this stage that this person is likely to be found guilty at this stage? My land sister is stretching beyond the limits. I invite you to reject that objection. Lastly, Your Worship, my land sister for the prosecution has stated that a friend being a surety, that he may not execute the duty. That is speculative, Your Worship. There is no proof in that regard, Your Worship. He's saying he's likely, he may not, but that is speculative, Your Worship. And Your Worship, a court should not rely on such baseless objection to deny the accused person bail. Where the law does not define the relationship, which kind of relationship that must exist for one to be a substantial surety.